Welcome back to HeirKare. The beginning of our podcast today is a little bit different as we had some recording challenges we did not realize right at the beginning of our previous recording session. So I'm just going to give you guys a brief summary to catch you up, and then we will jump back in with the group. Today's podcast, Erik and I are joined by Art Fowler. We all work together at the law firm Fowler Baker Shade in Johnson City, Tennessee. I, of course, live and work down in Suwanee, Georgia. Art Fowler is a partner at the firm. He's got his name on the building, and he is our probate guru. And so today we're having a conversation with him about what probate is. And probate is simply the court-supervised distribution of a decedent's assets, a decedent being the individual who died. Now, whether you have a will or whether you don't have a will, your estate is very likely to still go through the probate process. Again, if you don't have a will, the court will simply apply the state rules that give you essentially a default will. So with that background in mind, we are going to jump back into the three of us talking with Erik asking Art about some common client questions.
So Art, what are some of the kind of common terms that you get a question or a funny look from clients when you use that a probate term or a vocab word that maybe we in practice are used to using all the time, and then you say that and people are like, wait, hold up, what's that? What are some of those common ones?
First one is testate. Testate means that the person died with a will. The other one, or the opposite, is intestate, is where you don't have a will. So you'll hear those terms all the time. The other one that you'll hear a lot is the phrase letters. Letters means either letters testamentary, if you have a will. So you died, testate, you get letters testamentary. Or letters of administration, if you died without a will. And if you go to a bank and ask, what about the bank account? And they say, we need letters. That's code. I tell everybody that's code for that institution believes that you need to go probate for that asset. They may be right, they may be wrong, but that's what they believe. The other one that we hear sometimes is personal representative, administrator, and executor. They all mean the same thing functionally for our purposes, but an executor or executrix is the male, female for testate estate where you have a will, and administrator, administratrix is the female version when you don't have a will, or male and female version when you don't have a will. But I just use personal representative because it's just easier. They all kind of mean functionally the same thing for our purposes.
And so, Art, when you're going through a probate process, what does that typically look like, and what should people's expectations be as far as how long something like that would take?
They're kind of, every county is different in Tennessee about the way they do it. The process is similar in the sense that you're going to have some documents you have to file with the court initially. You're going to have this notice period where notice to creditors is published. So that's typically a 4-month period, waiting period. And then you're going to have the closing of the estate. That's where you do some documents again and theoretically distribute the money at that point in time, or the assets. But you may have court appearances that are required in some counties, and in other counties you may not. So it's really good to get a lawyer that's local, that practices in that specific county, that'll know the local rules, written and unwritten, about how you should practice and handle probate. The time frame is really dependent upon how well everybody gets along, where the decedent's assets were. I mean, if they were all over the place, it may take months just dealing with financial institutions who say they lost the paperwork, and you send it to them 5 times and they still don't have it. Mm-hmm. And it may be having to sell assets. And the worst part is just dealing with stuff, personal property, because that may have some sentimental value. Doesn't always have a lot of financial value. And so sometimes it's getting people over the hurdle of it's really not worth the fight for this particular item.
Yeah. Mm-hmm.
Yeah, so we get asked a lot from the planning side of things, now, we're going to set up all this stuff and are we going to have to probate? So when someone passes away, do we always have to do a probate, or is it something that we can sometimes have to do, or almost never have to do? What situations kind of lead to when we actually need to do a probate?
It depends upon what you want to do and what the assets are. So the answer is you don't always have to probate. So if you want to sell a piece of land, you may, more than likely, you're going to have to probate. If you're okay, and when I say land, I mean the house and the dirt around the house. If you're going to keep a piece of land like the house for more than a year, you may not have to probate. You have these other ideas that you can do or other avenues you may travel. If you don't have any land and the assets are less than $50,000, you have the option of doing potentially a small estate affidavit. That has pluses and minuses. If all you have is land, then you may be able to do like a muniment of title if you're going to keep the land, if you have a will, or you can do like an affidavits of heirship if you don't have a will. Like I said earlier, every county is a little bit different. Some counties will let you use muniment of title for like cars and stuff, not bank accounts. But other counties will not let you use muniment of title for anything but land. So it all kind of depends. And the best thing you can do is when you go see a probate attorney is just kind of have an idea about what you would like to happen, and talk to that attorney about what you would like to happen. And then we can figure out from there what's the best method to accomplish your goal.
Another question we get from a significant number of the clients, our clients have privacy concerns, and they want to know, well, if I have probate, is everything public record? Does everybody have access to all my information? So how does running through probate open up your stuff, if at all, to public record?
A probate lawyer that knows what they're doing should be able to limit the amount of access. So for example, the will always be a public record. The death certificate with the Social Security number redacted will always be a public record. The petition to open will be a public record, so it'll have information about the beneficiaries on the will, addresses, telephone numbers for the personal representative. That stuff will be public record. But what you can do if you have a will, or you don't have a will and everybody agrees to waive bond, or you have a will that waives bond, you're not required to put the value of the estate in that document. So you can avoid anybody knowing how much is actually there. If you waive accountings and nobody requires accountings, or you waive inventory and nobody requires inventory, really all you're going to have in the probate file is potentially a will, a death certificate, the opening documents, closing documents, some receipts. You'll see personal representative fees and attorney's fees, but that's really about it. A couple other little documents that are in there, but nothing else that I think is super secret or would provide too much information to somebody.
Mm-hmm. And so in your experience and with doing this over the years, what have you seen to be kind of the biggest mistakes that people make when they are stepping into that personal representative role and starting to administer an estate?
It's being too emotional, too close to the situation. So my wife tells me I'm a robot because my job requires me to try to sever emotion. And so I tell everybody, you got to think with your pocketbook or your wallet. That's what's going to drive us through this. You can't, just because, and I've had this, somebody express this to me, just because your brother 30 years ago knocked you down and took your bottle of Coke, doesn't mean you can hold that against him while you're the personal representative.
Right.
As the personal representative, your job is to collect and preserve all the assets for all the beneficiaries or heirs, which is probably you and other people that you may or may not like, and also for all the creditors that may be out there. And so you don't get to say, I want this or I want that. As a personal representative, you actually don't have a lot of control. You really have to jump through a lot of hoops. And the beneficiaries and the heirs have more control over you and can require you to do things. Again, the best thing you can do is get a lawyer that does a lot of probate and then they can kind of guide you through and give you the pluses and minuses for almost every action that you're going to take, because it won't be the first time that lawyer would have seen that.
Yeah. So I know I've joked with you in the office, hey, you realize that you pay me to try to work you out of a job by planning
Correct.
you out of probate. And your response is always, people mess it up
Yes.
anyway. So then they come see me. So what are some of the ways that you see where you see a plan come in and you can clearly tell what was supposed to happen, and then you can look at it and say, okay, that clearly didn't happen. So what are the ways that people mess it up the most, I guess, that you've seen?
The biggest one that I see all the time, there are two, and they're kind of the same vein. It's you do an online will because you're cheap and saving money. And all you do is then you double or triple my cost, because you never get the advice or the information that you need in order to fill out the online will correctly. And that's what you're missing, is sitting down with somebody and saying, okay, if I choose box A, what does that mean, and how does that affect box D later on? And then the other thing is what are called holographic or handwritten wills, which are perfectly valid. They just leave a lot of ambiguity. A lot of times, unless you just say, I want Art to get everything, most of the time they don't, then we're guessing. And you have to remember that the only time the will becomes effective is after you've passed away. So you can't tell us what you want. We just have to guess from what you wrote down. And sometimes that can be very difficult to figure out. So the best thing to do is go by and see a lawyer who primarily does estate planning, isn't a generalist and doesn't do a whole lot of stuff, and go talk to them. And it's going to cost you a little bit of money, but you're probably going to save a lot more, or you won't because you won't be here, but your heirs or beneficiaries will save a lot of money from the back end, which is me, where I'm trying to figure out or arguing with people what's going on. And it can get very, very expensive very quick, trying to figure out what you meant when you're not here to tell us.
Yeah. So that's let's say that they did come to see somebody and got a very large trust set up for them, and they got sent out the door with, hey, here's your trust, and here's all the things you should go do. What situations have you run into kind of most commonly of people that have this big huge plan, and then somehow that file ends up in your lap? And I ask this knowing that there are several that you and I talk about, because anytime that you get a trust and you pop in my office and say, hey, I've got a trust I need to pick your brain on.
That's right. We call it a steak dinner and a trust, because that's what it used to be. There was some entity from Middle Tennessee that would always come up to Upper East Tennessee and rent out the pier list and invite these people, and they would have a steak dinner, and they'd walk out with an overpaid document, and they didn't know how it worked. So the ones that I've seen in the past were when when Tennessee had inheritance tax, and when the federal estate and gift tax was lower, they would do like an AB trust. And so all the money would go into the first trust, which then would not be countable for when the second to die would not be countable in that the spouse's estate and gift tax. But the problem is now if you were trying to balance the money out, most of, not all the money goes into the A trust, and it's irrevocable, non-changeable. You can't do anything. That's one of the things. The other is you'll get the trust and nothing will be in the trust, so the trust is worthless. And so unless you point assets to the trust or actually put them in the trust, they're still the decedents. They're still yours when you die. So the trust just becomes worthless at that point. But then everybody thinks that the trust is there, and then we're trying to scramble around, find it. Some people can't find it. And then the worst is when they actually do the stuff, and then the trust disappears. And so we don't have a certificate of trust. We don't have any information on the trust. And so then we're trying to figure out what to do from there. And that's usually court intervention of some fashion, which again is just think of money going out.
So we've heard a couple different ways that things can go, right? If you have a trust and it's not funded, or you didn't keep it current. But some people don't do any planning at all. And so if they came to you and said, hey, my loved one did zero planning, how would that probate look different from a probate with a will, if at all?
Trying to, there's not a lot that's going to look different about it. Should be roughly the same. Terminology wise, it'll be a little different, but the steps will be almost all the same. Your dilemma just becomes, if you don't have a will, then you let the state dictate your final wishes.
Mm-hmm.
Whereas if you have a will, you get to dictate those on your own terms. So that's the only difference that I'm aware of between a will, dying with a will and dying without a will.
And so let's say someone's loved one has just passed away, and they don't know if they've done planning. They don't know, they're just at the hospital, got the news. What would you tell that person as far as when they need to be consulting a lawyer? What should their next steps be from an estate administration perspective?
I tell everybody, you don't need to do anything right away. Take time, because you're going to have this moment where you need to grieve, or at least start the process to figure it out. And I'm dealing with, in my line of work, I deal with two types of people. One type are the kind that really, they can't grieve until they get it over with. They've got a checklist, they've got to get it done. And the second type are the ones that grieve every time we talk about this case. So the first kind, they're going to try to get it over with. They're going to call probably within a couple days of the passing, and they're going to be hitting the road really hard. And the second one, it may be months before they call, and then the process will just drag out longer just because it's harder for them emotionally. I think taking the time to grieve is the most important thing, or just get your breath, because if it's been an illness that's been couple months or more coming, then you're going to be exhausted. The family's going to be exhausted. You're going to have all this emotion, and everybody grieves differently. And it's going to come out like people are frustrated at everybody, but probably it's just grief. And then you're going to get upset about it because you're going to think they're mad at you, and it's not. And tempers are high. Everybody's tired. So again, I would just take my time. In Tennessee, or at least where I practice, I think as long as you're actively seeking out some legal advice or taking steps to open the estate after about 60, 90 days, then you're okay as far as waiving the right to be the personal representative. I don't think any judge is going to not allow you to be the personal representative because they believe you waited too long if it's 60 to 90 days. You get past that date, then if somebody really wants to be hard, then they could start arguing that, hey, you waived your right. Still don't think a judge is going to do that. I think the judge is going to give you time. But 60 to 90 days is what I typically tell people that they should be doing something.
Before we kind of jump into, we'll kind of hit you with some rapid fire right here at the end. But before we jump into that, is there anything else about probate that you feel would be kind of important to know, or things that you would, common misconceptions that come in that you want to take a minute to sort of spell out, here's the right way to think about this, or anything like that?
So from probate, the way I look at it is it shouldn't be adversarial. Probate should be a time where information is communicated to everybody that's involved as much as you can to keep everybody in the loop. Some older school lawyers are still in this, it's everything. And if you file a lawsuit in front of the court in any way, it's litigious, adversarial, but that's not the way probate should be. You've got a lot of emotion floating around. And the other thing is just you've got to step back, especially if you're the personal representative, you got to step back and take as much emotion out of it and really think about dollars and cents. Is it worth it to take this action and spend this money, or is it not? So that's the final thought I would have.
And so what would you say to someone who is an heir and maybe they're getting impatient with the probate process?
It depends on where do I represent the heir?
No,
Or
let's assume
do
you
I
don't
represent the
represent
person?
the heir.
See, now you're getting litigious on us.
Yeah,
Let's say you don't
so,
represent the heir and you don't represent the personal representative. So you're at a soccer game and a buddy walks up to you and says, "Hey, this is what's going on." And it's been 9 months and I don't know what's happening.
I would first ask who the lawyer is, because I practice in this area enough that I know kind of everybody's tendencies. Some lawyers are really good, and they'll grind it through, and some lawyers are a little slower. And then I'll usually just tell people, hey, are you getting stuff in the mail from the other lawyer, from the court? If the answer is yes, I'm like, well, they're keeping you informed. Call the lawyer. Call the lawyer who represents the personal representative and ask them what's going on. And hopefully they're going to be, again, open and candid with you and give you as much information. If they don't, then maybe you do need to call a lawyer because they're treating it a little more adversarial than what you want. I'm involved in one right now that's been open for an extended period of time. And it's so old that then information it's harder to get. So if you can act sooner, you can hopefully grab that information faster if you need it.
I have one thing I wanted to circle back on. So let's say you got a new client coming in for a consult. What kinds of information do you if you have your perfect personal representative coming in to say, I'm ready to start probate, what things do they bring to that first meeting?
That is an awesome question. So we send out an information sheet that we want you to fill out. And if you answer those questions for me, there are about 5 questions on there that when I look at it, and then I'll look at a couple bits of information online, I will then have a very good idea about what the probate plan should be. So then when you bring me the documents that I ask for, I can confirm that plan, and then that makes our meeting shorter and more productive for you. The documents, you need a will, preferably the original will. You're going to need a death certificate. Some courts will take a copy, but I just always tell everybody to bring an original death certificate. If you have one that has death pending, the cause of death pending, it's okay. I don't need the final death certificate, just the one that identifies that he or she has passed away. Any and all statements from financial institutions or banks. If you have the decedent's checkbook, that's also good to bring, because one of the questions I'll ask you is, are you a joint owner of that on that account? And a lot of times people say, well, I don't know. And then is your name on the check? Yes. Okay, let me see the checkbook. And if it has the decedent top and then you bottom, that is 99% of the time going to be a joint account. So the assets that are going to flow through the estate and covered by the will are only assets that are owned in the decedent's name solely, don't have a beneficiary designation. Excuse me. So a joint account, well, the other joint owner gets that, but I need to know it on the front end. And then what we'll wind up doing with the financial institutions, if there are beneficiary designations or joint owners, what I prefer to do is go grab the contract for the financial institutions or the signature card for the membership agreement. So then I have in my file a document proving that this asset is not part of the estate. Because if we have siblings who don't like each other, don't trust each other, and one's on the accounts and the other one knows about the account, they're going to wonder why that account's not part of the estate. And so being able to provide them that information quickly helps out with the transparency. They feel heard. They feel like we're not trying to hide anything. And then also it means my client knows what is part of the estate and not part of the estate, and we have documentation to support that. Any bills are super important, because part of being the personal representative is make sure you give notice to creditors timely. And then if you have anything else that you think is important, bring that. Usually I'll get a copy of the deed, so I'll have that with me, and I'll kind of know about the real property the land and the house, how that is situated. Those are the will, death certificate, will if there is one, death certificates, bank statements, financial institution statements, and bills are the big things.
So, Erik, if you don't have any other questions, I'm going to throw one fun question out here before we close up, and that is this, Art. What is the coolest asset you have ever seen go through one of your probates?
Coolest asset?
Like most interesting, most memorable?
The most memorable one was a 1980s Corvette that was airbrushed. The top of the exterior of the hood had an airbrush picture of his wife in a Xena the Warrior Princess pose. If you lift up the hood, underneath there was his mistress in a Xena the Warrior pose. So that was, to this day, I still have that on my phone. It is the best. And everybody knew it. Everybody knew who he was. And it was just the funniest thing I've ever seen. So.
That is definitely memorable.
It is.
And on that bombshell, Art, thank you so much for being here with us today. And we do just want to remind everyone that the information provided here today is just that, legal information. It is not advice. And we strongly, strongly suggest that if you are in a situation where you're looking at doing a probate, that you contact a qualified probate attorney. Thanks so much.
Thank you.